Hello, my name is Jeff Lewis. I'm National Director of the Patriot Coalition, and the presentation you're about to see is on Article 5, A Brief History and Contemporary Efforts to Trigger a Convention. It was prepared by myself and our General Counsel, Mr. Richard D. Fry, who may be joining us. And it's going to be about 2 hours. What we're going to cover today is 4 basic areas: the nature and character of the federal government, the Article 5 amendment process, history of the current Article 5 movement, and the current promoters of an Article 5 convention. When we refer to sovereign citizen, we're using the term in the same sense as used by the founders and as suggested in the Declaration of Independence. We are not referring to the sovereign citizen or common law citizen movement. There's really only one question we need to answer to determine whether we should support or reject an Article 5 convention as a solution. And that question is, why should we believe that amending the Constitution will make public servants uphold it? It is our, I would say, learned, expressed, sincere, researched and analyzed opinion that an Article 5 convention is the wrong solution to the wrong problem. But is the Constitution the problem, or are we? Should we amend the 10 Commandments because people break them? Would you amend your marriage vows if your spouse cheated on you? If public servants won't uphold the Constitution, why is amending it the solution? So let's get into the first area, the nature and character of the federal government. Because we need to understand how our government is supposed to function, what its purposes are, and what the relationships are. You know, generally, when we think of the federal government, and we've been taught this between the media and the talking heads and government officials themselves, everybody generally thinks of the federal government as just what's in Washington, D.C., or what's based out of Washington, D.C., the executive, legislative, and judicial branches of the federal government, or the central government, also referred to as the general government. But the federal government includes a lot more than what goes on in Washington, what comes out of it. The components of the federal government include we the people, state government, and the central government. Well, let me get one little pointer here. Let me go back to that. This is like a bowl of water, obviously. And the largest component that feeds all government, whether it's a state government or a central government, is we the people. And we're still fighting with that. That's why. Yeah. The state government, think of this as the petals on this flower that's sitting in a bowl of water or in a vase. And at the core of that is the central government or general government. That would be what's in Washington, the President, Congress, and the federal court system. And neither one of those can survive, state government or the central government, without we the people. So why are citizens included in the government? If you read the Declaration of Independence, one of the key components of that is right in the very beginning, so that to secure these rights, and these rights are unalienable God-given rights, they come from our Creator, governments are instituted among men, deriving their just powers from the consent of the governed. I'm using North Carolina's Constitution as an example, but you'll find this in either your Bill of Rights or your Declaration of Rights in every state constitution. something that speaks to what Section 2 does in Article 1 of the North Carolina Constitution's Declaration of Rights, that all political power is vested in and derived from the people. All government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. In Federalist 45, James Madison said, the state governments may be regarded as constituent and essential parts of the federal government, whilst the latter, talking about the federal government, is nowise essential to the operation and organization of the former, the states. So what he's essentially saying here is federal government needs the state governments to survive and thrive. State governments do not need the federal government to survive and thrive, at least under the federal constitutional republic that the Founding Fathers gave us. If you look at the components of the federal government, we the people down here at the bottom, the sovereign people, are the foundation. And we gave up some of our sovereignty to form the state governments. In the state, you hear people talk about the states are sovereign. Well, they are cloaked in sovereignty, but they're not sovereign in and of their own. What sovereignty the states have is on loan from the people. Same thing for the central government, which is the executive, legislative, and judicial branches of what we typically call federal government. And you notice that parts of these are in pink. We the people, well, we don't get to choose ourselves, but we certainly have a direct say-so via the voting to choose our governors, our state legislatures, our state judges in most states. There's some where the judges are appointed, but in most states they're elected. We get to vote for the president. We get to vote for the members of Congress in the House and the Senate. We don't have a direct say-so to the federal judges. So what ties the federal government together? The Supremacy Clause, Article 6, Clause 2, says this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Notwithstanding is a term of art, a legal term. You see that's where you usually see it, which means regardless of what any other law says, this is it. That's why they call it the Supremacy Clause. And why it says they shall be supreme law of the land. What ties the federal government together? Well, before public servants may assume office, they are required to take two oaths, an oath of office and an oath to support the Constitution. We're going to talk about both of those a little bit. Do you think they only take one? Well, they really take two. The oath of office, if you look at the President's oath, is to faithfully execute the laws, to uphold the office of presidency. If we're talking about the governor, he's taken an oath to do his duty as governor. The legislature, the same way, dog catcher, whoever takes that oath. But they're all required to take an oath to support the Constitution under, I'll back up a slide, under the Supremacy Clause, because that applies to, actually it's the next one, those to support. Article 6, Clause 3 is the oath clause. Your federal senators and representatives, that's Congress, members of the several state legislatures, your state governments, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So there's your executive and judicial, so the president and your governor, and the federal and state judges. And as far as local government, your county, your city, your borough. Those local governments are political subdivisions of the state government. So your mayor, your county commissioners, they're all required, your sheriff, police officers, they fall under the judicial officers area. They're all required to take an oath to support the U.S. Constitution. So who shall be bound by oath of affirmation to support the Constitution under Article 6, Clause 3? Essentially, every federal and state officer are bound to support the Constitution. The President, his oath is found in a different part of the Constitution. He's bound to preserve, protect, and defend the Constitution. And the defense is, he's also wears another hat in time of war, Commander-in-Chief. The characteristics of the oath, it establishes a personal duty. The oath is active and affirmative duty, not a passive duty. It's unlimited geographically and politically. So they're required to uphold and support the Constitution regardless of whether they're in their state or anywhere else in the country or anywhere on the planet. And that speaks in part to the allegiance and protection duties, and we'll get into that. It is a perpetual duty. It lasts as long as you're alive. It doesn't expire. And this is the oath to support the Constitution. The oath of office expires at the end of your term of office. But the oath to support the Constitution does not expire. You'll hear a lot of veterans say, my oath didn't expire. It doesn't. And it's implicit that they must have a working knowledge of the Constitution. If your state rep or your congressman or your senator takes the oath without that working knowledge of the Constitution, he's committed perjury. It's a crime. We don't hold them accountable to that, but it is actually a crime. The characteristics of the oath to support, well, that Constitution was written for the average citizen or voter to understand. And except for terms of art like original jurisdiction or militia, which we can go into some detail about those, but for example, the Second Amendment has the same meaning now as it did when the Constitution was ratified. Militia was a term of art that everybody understood then, but very few understand today. And there are no constitutional militias in the United States today. These paramilitary grassroots groups that are calling themselves militias are by definition vigilante organizations. They're not militias. Not constitutional, anyway. The restrictions of the oath to support: one under oath may not propose, sponsor, support, or vote for an unconstitutional proposal, nor may they enforce an unconstitutional enactment. In addition, they must actively resist any proposal or enactment with all the power of their office and personally. Different offices may have different resources available, but the duty of all office holders is the same. So when you hear your state rep say, and you approach them about an intrusion by the federal government, and they say it's not my job, that's the federal government. If the intrusion is a violation of the Constitution, it is absolutely their job, because they are part of, just like a lot of us wear different hats with different volunteer organizations, or with a church, or Boy Scouts, or a Tea Party group, or pick one. Public servants wear two hats in state government. One of them is for their state government duties, and one of them is to support and uphold the Constitution, because they are also part of the federal government. The duty of the oath to support is, in essence, one under oath to support is, in essence, a federal officer with the duty to protect the federal Constitution, which is the Republic. These are the fundamental principles of federalism that everybody needs to understand. And the reason we felt that there was a need to go into this before we get to Article 5 is, we posited up front that this is the wrong solution to the wrong problem. And we don't need to amend the Constitution. to fix the problem. They already have enough, all the constitutional authority state governments do, to address, between state governments and the people, to address all the abuses by the federal government or the central government. So who's required to take that oath under Article 6, Clause 3? That's all these folks in black. It's everybody. Everybody in the central government, President, Congress, federal judges, in the states, the governor, state legislature, state judges, in your city, county, town, the mayor, the city council, the magistrate, the sheriff. So everybody that's anybody in government, federal, state, or local, is required to take this oath. And we need to hold them to it. So what's the duty to protect? And what are the sources of the state's duty to protect the citizens' right? Their officers are under oath to support the Constitution, which is not to infringe on our unalienable rights. And states are under a duty of allegiance and protection. Allegiance and protection is the ancient inherent principle of sovereignty that established the mutual obligations between a sovereign and its subjects or citizens. It was noted at least 3 times by the Apostle Paul in the Bible, 3 times in the Declaration of Independence. It was recognized by the Supreme Court in many cases. It is the allegiance that you refer to when you say, I pledge allegiance to the flag. You know, in reference to the Declaration of Independence, for example, in the indictments against King George, that was one of the main indictments, is that he had removed them from his protection. He had dropped his allegiance to the people. And allegiance and protection is a mutual arrangement or relationship. We have, as citizens, we have a duty to be loyal to and to protect the republic. Not the government, but the republic itself, which is, in this case, us. And there's supposed to be a balance of power. And we, the people, are the pivot point here that controls the balance of power. When our constitutional republic, applying the principles of federalism properly, is in balance, the state government and the central government are pretty even. But when it gets out of whack, well, we'll get to that. I'm getting ahead of myself here. In Federalist 28, Alexander Hamilton said, it may safely be received as an axiom in our political system that the state governments will, in all possible contingencies, afford complete security against invasions of the public liberty by the national authority. In Federalist 28, he says, power being almost always the rival of power, the general government will at all times stand ready to check the usurpations of the state governments. It's a two-way street. And these will have the same disposition towards the general government. The people, by throwing themselves into either scale, will infallibly make it preponderant. If their rights are invaded by either, they can make use of the other as the instrument of redress. This is where I was getting ahead of myself. If the central government, that in Washington, gets out of hand like it is right now, we the people need to throw our weight toward the state governments, rally the state government to bring this back into balance, the balance of power. And if the state government was intruding upon our rights, then we should shift our weight toward Washington to get the state governments in check. One of those don't work. Well, we did have according to the Second Amendment, the right to keep and bear arms shall not be infringed is the part that most people hinge on or focus on. But at the very beginning of it, it spoke to, and I quote, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Well, it didn't say a well-regulated militia being a good idea or preferable. It said necessary. And the free state is your state. If it's Virginia, California, North Carolina, we gave up that. That's the state. What was the state militia got nationalized into the National Guard. Hamilton 28, Federalist 28 said, if the representatives of the people betray their constituents, there is then no resource left but in the exertion of that original right of self-defense, which is paramount to all positive forms of government, and which against the usurpations of the national rulers may be exerted with infinitely better prospect of success than against those of the rulers of an individual state. If circumstances should at any time, and this is from Federalist 29, if circumstances should at any time oblige the government to form an army of any magnitude, that army can never be formidable to the liberties of the people while there is a large body of citizens, little, if at all, inferior to them in discipline and the use of arms, and their own rights, and those of their fellow citizens. I had a reference to the North Carolina Constitution earlier. Here's another, Tennessee, same thing. The government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. We the people needed to have and maintain the ability to defend ourselves even against our own government if necessary. And that is what the Second Amendment was all about. Not about hunting, not even about protecting your home. I'm going to hold off on the questions until the end, unless somebody has one that they would like me to go ahead and address. And I don't see any in the chat, so I'm going to get through the formal part of this. I'm going to move along. While we're here, Article 5, the amendment process. Where's the authorities for amendments and or a new constitution found? Well, let's start with the Declaration of Independence, that whenever any form of government becomes destructive of these ends, it is the right of the people, that's the sovereign authority of the people, that's in the United States, the people are the sovereign, not the king, not the government, to alter, and that's where Article 5 comes in, or to abolish it. That's the inherent authority that the people themselves have, and to institute new government, which would be a constitutional convention, or as some refer to as a plenipotentiary convention, which is essentially unlimited to write a new form of government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So, whether we're talking a constitutional convention, a con-con, or amendments convention, well, a constitutional convention or con-con, by definition, is a new constitution. An Article 5 amendments convention is to make changes to an existing constitution, and they are technically different. But, and it's a big but, Article 5 doesn't set any limit. There's no limits on the scope of an amendment. So an amendment can be the change of one comma or the change of everything but one comma. A constitutional convention and an Article 5 convention, the terms, are a distinction without a difference. And in this current Article 5 movement, that's a diversionary tactic that's used when folks use the term con-con or constitutional convention in reference to an Article 5 convention. The proponents will use that to discredit the message and the messenger of those opposed to an Article 5 convention by saying, and I'm sure you've heard this over and over, well, this is not a con-con, this is not a constitutional convention, you don't know what you're talking about. Well, by definition, they're correct, but there is no difference in it because you don't have to completely rewrite the Constitution to change our form of government. So what is the real issue? Do we fear a change in the language of the Constitution? No. We should fear a change in the form of government and our sovereign status. Our General Counsel's, just to give you an example, said that 5 words can change everything. And what 5 words could do? Just 5 words. The state sovereignty is here, is abolished. Well, that would kill federalism. It would also kill the protections that we have now on paper, where if the federal government gets out of control, the states should be standing in between we the people and a rogue federal government. States would have, just changing a few words, states would have no authority or duty to keep the central government in check, to keep the central government from infringing on your unalienable God-given rights. So let's look at Article 5, and I'm not going to read this whole thing to you because we're going to go through it in parts. And Madison said the purpose of Article 5 in Federalist 43, it guards equally against that extreme facility which would render the Constitution too mutable and that extreme difficulty which might perpetrate its discovered faults. It moreover equally enables the general and the state governments to originate the amendment of errors, as they may be pointed out by the experience of one side or the other, or on the other. He doesn't say to rein in a rogue federal government. And they didn't say they had created, they weren't so arrogant as to presume that they had created a perfect union, a perfect government. You read the preamble to the Constitution, and it refers to it as a more perfect union. It was better than what they had. And when it's making reference here to the experience of one side or the other, that because of the different duties that state governments have, as opposed to the general government or central government, there might be areas where Congress has more experience, especially dealing with trade and foreign affairs, that if there was an amendment that was necessary, they might be the ones, just from having to deal with the flaws in an existing component of the Constitution, to propose an amendment to fix that problem. And the same is true of the state governments, just from their areas of expertise and experience. Thomas Jefferson's advice on interpreting the Constitution, this is my title, but the Constitution says what it means what it says. Jefferson said, on every question of construction of the Constitution, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debate, and instead of trying what meaning may be squeezed out of the text or intended against it, conform to the probable one in which it was passed. Well, we don't need to just do that for the 7 articles of the Constitution and the Bill of Rights. Every amendment that's been added to the Constitution, if we're wanting to interpret and understand it as far as the intent of that amendment or that section or clause, we need to look at the debates and the discussions that went on at the time in which that particular amendment was proposed and ratified. So let's look at the Article 5 process. There's essentially two phases. There's the proposal phase, which we've got here in pink, and the ratification phase, so light green. And there's 2 different ways to propose amendments. Congress can propose amendments, or Congress can call a convention after 2/3 of the states apply for a convention. Congress calls it. So it really starts up here. 2/3 of the states apply, Congress calls, and then the convention proposes amendments. So it's not really the states that are proposing the amendments. It's the Article 5 Convention for Proposing Amendments that proposes amendments to the Constitution. And in either case, whether Congress proposes the amendment or the convention, which Congress called after 2/3 of the states applied for it, the ratification methods or options are the same. Congress can propose conventions in the states, or can just send it to the legislatures. And if 3/4 of the state legislatures ratify it, it becomes a part of the Constitution. So, quick follow-up on this. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments. That's here. Or the Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. That's here. And it doesn't matter whether Congress proposed the amendments or the convention for proposing amendments. When ratified, either one, when it's ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as the one or the other modes of ratification may be proposed by Congress. So it's Congress's choice on that. And that's what we've got down here. The proposal and the amendment phases of Article 5 are pretty simple once you break it down. Now, the power granted to Congress regarding constitutional amendments extends beyond Article 5. If you look at Article 1, Section 8, and that's actually Clause 18, it grants Congress power to make all laws necessary and proper to fulfill duties. And that's referred to as the Necessary and Proper Clause. It says that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This all the other powers. In Article 5, it says Congress may propose. When it gets to the part about the convention, it says shall. Congress shall call a convention for proposing amendments. Shall is must. Now, whether it was a must or may, it's still a power granted to Congress. Whether it's a discretionary power or a mandate, it's a power. And it's the Necessary and Proper Clause gives Congress the authority to do things far outside of just the limited language in the text of Article 5. But Congress shall propose amendments. Congress shall call a convention. Congress shall propose the mode of ratification. And they may make all laws necessary and proper to fulfill its Article 5 duties. What powers granted to states regarding constitutional amendments? Well, the states may make application to Congress for an Article 5 convention for proposing amendments, and the states may hold a ratification procedure as directed by Congress. That could be the state legislatures ratifying. It could be the states calling a ratification convention at the direction of Congress. So who controls the Article 5 process? Because that's one of the arguments that you hear in the current push for an Article 5 convention. The proponents say, well, Congress doesn't control it. Well, the states don't control it. The Constitution itself dictates. Everybody has a role in this. It's not just the states. It's not just the federal or central government. It's not just we the people. And this is another overview. The people are in pink. So we the people, the state governments, and the central government are all part of the federal government. And in the amendment phase, Congress has two primary roles. Congress can propose amendments, or Congress can call the convention after the states. The state government is part of the federal government. States can apply for a convention. State legislatures can ratify in the ratification phase. And the people attend the convention. It's citizens that are delegates or deputies or commissioners at this Article 5 Amendments Convention. And that convention is a deliberative body performing a deliberative process in the same fashion that Congress is and your state legislatures are. Another simple breakdown of the Article 5 Amendment process. I'll get my pointer out of the way. 2/3 of the state legislatures can apply to Congress. Then there's a convention called by Congress. Those amendments go back to Congress initially for Congress to choose the method of ratification. Same thing as if Congress had proposed the amendment or amendments. They both go to either 3/4 of the state legislatures or to convention. So control of an Article 5 amendment process, who controls it? An Article 5 convention for proposing amendments is a federal convention. It is not a convention of states. Congress, state legislatures, and the people all play a role, but the Constitution itself determines in what capacity. The entity, who controls the Article 5 convention itself, the entity that calls a convention makes the initial rules, determining such things as where and when the convention will meet and recommending basic rules of the convention. This is Congress's authority under Article 5 via Article 1, Section 8, the Necessary and Proper Clause. Now that's the basics and the fundamentals of the Article 5 process. Not seeing any questions over there. I want to get into the history of the Article 5 movement. We're about halfway through the tough part here. The Ford and the Rockefeller Foundation's pursuit of globalism and Article 5. In 1963, the Ford Foundation established the Fund for the Republic with about $16.5 million. The Center for the Study of Democracy got $25 million. Combined, that's about $41.5 million in 1963 dollars, and depending on how you do the math with inflation and which is really the deflation of the dollar, value of the dollar. In 1963 dollars, it was $41.5 million. In today's dollars, it's somewhere between $500 million and $1.2 billion. And the mandate was to write a new constitution for America. They did not spend this kind of money just because they were bored. The guy they hired to head up the project was Rex Tugwell. Rex Tugwell was a professor from Columbia University. He headed up FDR's New Deal, or the New Deal Brain Trust. He's an internationalist. He was a member of the committee to frame a world constitution. But they hired 100 academics and professors to help, and it took them 10 years. The final product that they released in 1973 is called the New States Constitution, and it abolished the states and set up regional, federal regions in their place. Well, regionalism and regional governments are, if you're familiar with Agenda 21 and Sustainable Development, that's a key component of that. And if you look at the Affordable Care Act, or what we call Obamacare, you had the individual mandate, which is ridiculously unconstitutional. But of the exchanges, the way that you were going to participate in this new government-run insurance, you had the federal exchange, you had a state exchange, and you had healthcare compacts, interstate compacts. Well, in all three cases, it's still government entities controlling the insurance industry, controlling who gets insurance. I called it a three-card Monte because the people never win. In 1973 through 76, Nelson Rockefeller, and you recall, for those young folks, Nelson Rockefeller was grandson of John Rockefeller, who started the Rockefeller Foundation. But he was also Gerald Ford's vice president. When Nixon resigned, really, he wasn't just a businessman. He was a congressman, as vice president. What young folks? When he was a congressman, he was very influential in the House of Representatives, and as vice president, he was the president of the Senate. He pushed for an open convention in the early to mid-'70s under the Balanced Budget Amendment banner and promoted Rex Tugwell's New States Constitution. The American Legislative Exchange Council was also started in 1973. In the mid-'80s, the Ford and Rockefeller Foundation's pursuit of globalism and Article 5, they pushed for a limited convention under the Balanced Budget Amendment banner. And Supreme Court Chief Justice Warren Burger was approached by professors with this proposed constitution, which abolished the states and set up federal regions. The Rockefeller Foundation was very active in the promotion of a convention. Well, that didn't sell. In the 1990s, they began pushing a convention of states under the banner of a Balanced Budget Amendment. From 2010 to 2014, it's been promoted as a convention of states under state control, under the Balanced Budget Amendment banner with a flavor for everyone's taste. You're promoting it as a limited subject, limited topic, or limited to a specific amendment. So whether you're a single amendment convention camp, a single subject or topic, such as balanced budget or term limits, or limited subject reining in putting fiscal restraints on the federal government, there is an pro-Article 5 movement from the conservative side that's been promoted by the Ford and Rockefeller Foundations for years now. This is not new. It was not a grassroots effort. One of the interesting new aspects of this is an end-run around Article 5 using the Interstate Compact Clause in Article 1, Section 10, Clause 3, and that's being promoted by the Compact for America. If you want to learn more, read the Ford Foundation's Pursuit of Globalism, the Con-Con Connection, and there's the web address for it. This was written by our General Counsel, Mr. Fry. Well, there's the history, but since we don't live in the past, and this section here on the current promoters of an Article 5 convention is just an overview, because there's a lot more players involved in this that when we initially prepared this Article 5 presentation, we're still doing our research. We could do an all-day seminar on this. We're trying to keep this short and sweet. There are big money special interests behind the current movement, and make no mistake about it, this is the most sophisticated, well-funded push for an Article 5 convention in our lifetimes, if not in the history of the United States. The billionaire, I call them the Billionaire Boys Club, and they come from the left and the right. The Koch brothers, George Soros, Leo Limbeck III are three of the prime movers and shakers of the new Billionaire Boys Club advocates for an Article 5 convention, in addition to the organizations set up by the Ford and Rockefeller Foundations that have been at this for 50 years. The non-governmental organizations, if you're conservative or Republican, you're probably very familiar with most, if not all, of these. These folks set these up. Heritage Foundation, Cato Institute, Americans for Prosperity, the American Legislative and Exchange Council, the National Council of State Legislators, ALEC and NCFL, the primary memberships are state legislators and corporate America. Tea Party Patriots, national. Citizens for Self-Governance, which is the parent of the Convention of States Project. Freedom Works, the Independence Institute, and the Goldwater Institute. Major media figures, Rush Limbaugh, Sean Hannity, Glenn Beck, Mark Levin, Mike Huckabee, Herman Cain, Neil Bortz, Sarah Palin, Alan West, all promoting an Article 5 convention. Why are these talking heads, in specific, Rush Limbaugh, Sean Hannity, Mark Levin, and Glenn Beck, why are they supporting an Article 5 convention with such vigor? Follow the money. Perhaps it's because they're getting paid big bucks by NGOs. Since 2008, Sean Hannity has received on average $1.3 million a year from Heritage Foundation. Rush Limbaugh, about $2 million a year from Heritage. Mark Levin, $1 million plus since 2010 from Americans for Prosperity. Glenn Beck since 2010, over $1 million a year coming from Freedom Works. And these are the NGOs that were set up by the billionaire boys clubs to manipulate and control government. And that's just from the right. So what's the common thread between these NGOs? Freedom Works, the Independence Institute, Goldwater Institute, Cato Institute, Heritage Foundation. Well, most of them are members of the State Policy Network, which is funded by the Charles Koch Foundation, Castle Rock Foundation, that's Heritage, Freedom Works, Cato Institute, Independence Institute, Goldwater Institute. Most are connected directly or indirectly to the Koch brothers. Heritage supports Article 5 and supports or funds Sean Hannity and Rush Limbaugh. They're all funded by Charles Koch, Castle Rock, and Adolf Coors foundations. These are supposed to be the conservative, the good guys. Well, this is just a smattering of the folks that want to change our form of government. Michael Ferris, who heads up the Convention of States Project, said we don't need sometimes you don't need a change in personnel, you need a change in structure. Rex Tugwell, the Emerging Constitution, which is the new state's constitution, is ridiculous. Kansas Secretary of State Chris Kobach is a constitutional law professor. Was the lead counsel to U.S. Attorney General John Ashcroft in the Bush administration, and one of the pieces of legislation and policy that Professor Kobach, now Secretary of State Kobach, helped write, I'm sure you're familiar with, the Patriot Act. Tea Party Patriots, Hannity, American Legislative Exchange Council. Citizens for Self-Governance was founded by co-founder of Tea Party Patriots, Mark Meckler. Both organizations, these national organizations, the Tea Party Patriots and Citizens for Self-Governance, funded by an NGO set up by Leo Lembeck III, Texas billionaire. Citizens Initiatives is run by a gentleman out of North Carolina named Charles Kaplowitz, and who believes we can have a single amendment convention. And Rob Nadelson from the Independence Institute, a retired law professor, wrote the ALEC handbook for state legislators on Article 5. He also wrote, you'll hear Mr. Ferris refer to the Article 5 compendium, which is a compilation of white papers written about Article 5. Well, that was also written by Professor Nadelson. Keep in mind where Professor Nadelson works for a non-governmental organization, NGO, that was set up, created, and funded by the Billionaire Boys Club. These are not grassroots groups. These are not grassroots folks. If you follow the money back, the deeper you dig, the dirtier it gets. Mark Levin's book, It Feels Good. It's part of what I call the carrotocracy we live in, where they're dangling carrots that sound appealing on the surface. And they actually have them for people on the left and the right. Our general counsel said, if we the people won't hold our elected officials accountable for not upholding the Constitution now, by what stretch of the imagination do we think they will follow a new and improved Constitution? The Convention of States Project believes we need to rewrite the Constitution. Their communications director, back in January of 2014, said, and I quote, I think the majority of Americans are too lazy to elect honest politicians, but I think some men and women could be found who are morally and intellectually capable of rewriting the Constitution. I'm going to play this. I don't know that the video, this is only about maybe 20 seconds worth, but you can hear Mr. Ferris say it himself. At least in theory. Well, if you go to this link, and I'm going to share this presentation, so you don't have to worry about writing this down now. When they launched the Convention of States Project, that was what Mr. Ferris said in the introduction of it, that sometimes you don't need a change in personnel, you need a change in structure. What they're calling a limited convention is not a limited convention at all. And we don't use the runaway convention argument. And I know that was very successful for the John Birch Society and Eagle Forum and others. Over the past quarter century, they were 100% successful making that argument to help prevent the triggering of an Article 5 convention. And that's what the Convention of States Project is hoping that you're going to latch on to, is the fear of a runaway convention. Well, that's kind of a misnomer, because there's no limitations on what an amendment can include, or that you can even limit it to one amendment. Article 5 says Congress shall call on the application of 2/3 of the state legislatures a convention for proposing amendments, plural. Yes, thank you. Thank you for the typo check. Yeah, I was noticing that too. We got a few typos in here. But we're not funded by the Billionaire Boys Club. Their limited convention claims to impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. Those are three major carrots. Balanced budget, rein in the federal government, and term limits. And yet, I'm going to back up and look at that one again. Limit the power and jurisdiction of the federal government. What was the entire purpose of the Constitution if not to establish the amount of power and the limits of the jurisdiction of the federal government? So when it wouldn't matter if you had this first part or the last part at all in their model application. Under just this clause here, that's a key component. This is what Georgia, Florida, and Alaska have already adopted in this current session in their applications, is this language. There would be nowhere for a convention to run away to. When I debated the Convention of State Staff Counsel, Mr. Robert Kelly in Yorktown back on the Ides of March, he admitted that their application was broad, that it opens up the whole Constitution. If you go to youtube.com to Patriot Watchdog, you'll see the video of Convention of States admits their application is not limited. Professor Nadelson, who wrote the ALEC Handbook for state legislators and the COS Article 5 Compendium, and he was the prime source for Mark Levin's Liberty Amendments, tells legislators one thing: the interstate conventions always have determined issues according to a one state, one vote, although a convention is free to change the rule of suffrage. That's straight out of the Article 5 ALEC Handbook that Professor Nadelson wrote on page 15. He says initial suffrage is one state, one vote, with decisions made by a majority of states, but the convention may change both rules. From page 16 of that handbook. But then he tells the public something else, because they're wanting to allay the fears of a potential runaway convention, or that, Phyllis Schlafly of Eagle Forum had put out a letter or an article that suggested that it might not be one state, one vote. It might be apportioned, just like Congress is, or like the Electoral College. Well, Professor Nadelson, in a rebuttal to the article that Phyllis wrote, said a convention for proposing amendments is a meeting of sovereignties or semi-sovereignties, and each state has one vote. He didn't put the qualifier in there. Well, that may be the initial. But this convention, being a deliberative body performing a deliberative function under the authority of the Constitution, is just like Congress and your state legislatures. It makes its own rules. Nobody outside of that deliberative body, that constitutional body, can tell that body what rules to make or how to conduct its business. And the courts have ruled on this, have affirmed this. Do you want to see the video where Convention of State Staff Counsel Robert Kelly admits that their application is not limited? Here's the link to that. You can download it directly, or like I said, you can go to YouTube, the Patriot Watchdog, and look at our Article 5 playlist. You can also find it on our Article 5 project site, rejoinordie.com. Michael Ferris, who's the head of the Convention of States Project, wants to change the Supreme Court to a European model. In an article that was published on the Convention of States Project site, or Citizens for Self-Governance, I've actually seen it on both sites, from New Year's Eve 2013, said, if I'm a delegate to the Convention of States, I will propose reconfiguring the Supreme Court after the model of the European Court of Human Rights. There are 46 nations in that court's jurisdiction, and every nation appoints one judge. We should expand the Supreme Court to 50 justices and have the states appoint the justices for a specific term, 6 or 8 years, with no right of reappointment. We want to go after a European model. He's wanting to limit the government. We've got 9 justices now. It doesn't matter whether the states appoint judges or the president. It doesn't matter who appoints them. If they're not held accountable to their oath, it doesn't matter if you have 1 or 1,000. But the last thing we need to do is follow the European court model. He also wants, and this is if you've got kids or grandkids, you should be very deeply concerned about Michael Ferris's Parental Rights Amendment. Section 3 says, neither the United States nor any state shall infringe on these rights. Sections 1 and 2 are the warm, fuzzy assertions of what parental rights are. But Section 3 says the federal government, state government, can infringe on these rights without demonstrating that its governmental interest as applied to the person is of the highest order and not otherwise served. Well, according to Dr. Edwin Vieira, and there's a clip in one of the videos you'll find on our Article 5 playlist, in which Dr. Vieira explains in detail that this governmental interest doctrine is a judicial doctrine, and it's a false doctrine. And what it's saying is essentially that if the government decides that there's a governmental interest that's higher than your interest as a parent, they can infringe on these rights. Currently, there are no constitutional authorities for the government to infringe on parental rights at all. What Mr. Ferris says we need this for is to protect us against UN treaties, such as the UN Convention on the Rights of the Child, that would infringe on domestic policy and domestic law, and suggesting that if the President and the Senate get together and sign some foreign treaty, that international law might dictate domestic law or trump domestic law. Well, that totally ignores the Supremacy Clause, Article 6, Clause 2 that we talked about earlier. If a law or a treaty is not made in pursuance of the Constitution, it's not a law at all, or a treaty, and we're not bound by it. Mr. Ferris claims that they want to limit the federal government or central government or reduce it. And yet, we've seen 3 of his proposed amendments. He says he's got 7 altogether that he'd really like to implement. Every one that we've looked at is an expansion of government or a reduction of individual rights, including parental rights. This is their website. This parental rights amendment exists in Congress right now as House Joint Resolution 50, HJR 50, and there's at least a couple of dozen members of Congress from the House of Representatives, that are co-sponsors to HJR 50. They make claims that their own people refute, such as why a convention of the states is the safest alternative to preserve our liberty, in page 10 of their Article 5 handbook. And they say, we know how a convention of the states would operate. Well, this gentleman is not with them anymore. He left after myself and our general counsel, Mr. Fry, debated Mr. Kinney, the executive director of Convention of States, and their North Carolina Convention of States director in Raleigh, North Carolina, back this spring. I want to say it was in April. You should go listen to this audio clip. And this is an excerpt from that audio clip of retired Navy Captain Jim Kinney, who was then Executive Director of Convention of States. Well, this was before he joined Convention of States, what he says up here. It says, some, and not without justification, fear this approach as too radical and too fraught with risk. Their concerns are rational. If we embark on this journey, we cannot be certain of the outcome. Now, when we confronted him with his own words at the Article 5 debate in Raleigh, I think Mr. Kinney was embarrassed. Claimed that he didn't know what he knew last fall. What he knew once he started working for becoming a salesman for the Convention of States movement. Our general counsel started us saying that and we're not sure exactly who to attribute this to, and we've kind of trimmed it down a little bit. But essentially, when an honest man finds he's wrong, he either stops being wrong or he stops being honest. We believe that Mr. Kinney is an honest man and that he decided to stop being wrong, and he's no longer with the Convention of States project. Talked about Kansas Secretary of State Chris Kobach, co-author of the Patriot Act, proponent of indefinite detention of U.S. citizens. On February 20th of this year, Mr. Kobach, said, the interesting thing, he's talking to a GOP group in Kansas, says the interesting thing is only conservatives are paying attention. If you ask a liberal, he'll say, what is a convention? What's Article 5? Because we're the only ones that care about the Constitution. Well, this is a, you mean not putting words in his mouth. There's a link. You can watch the video clip yourself of this constitutional law professor saying the left's not even concerned with this. Well, for the past 8 months, that's what we've been hearing from the right, is that liberals and progressives and socialists and Marxists, they're not paying any attention and they don't care about this at all. Well, that's a lie. It's a huge lie. And again, here's the link to the video. The video won't play in the webinar, but you can certainly go watch it yourself. See that I'm not putting words in his mouth or exaggerating this. And the reason I say it's a lie, that they just didn't know better, is because the left and the right, both the Soros-funded crowd and the Koch-funded crowd, held a conference, and they called it a constitutional convention in 2011. If you go to their websites, con.org, was a who's who of progressive and conservatives, including Move to Amend, some of which are funded by George Soros, the Green Party, Independent Progressive Politics Network, Communication Workers of America, Lesbian, Gay, Bisexual, Transgender Constituency Group of the AFL-CIO, the Democracy Convention, Progressive Democrats of America, and Democrats.com, host of the Young Turks, Cenk Uygur, which is funded in part by Soros, the Cato Institute, funded by Koch, Goldwater Institute, funded by Koch, American Legislative Exchange Council, funded by Koch. Now, I've inserted this in here before I get to the who's behind this on the left. I'm not worried about Soros, and that's something that Farah says, well, if you want to be afraid of George Soros, you go ahead. I'm not afraid of George Soros. I'm not afraid of teachers' unions. Well, I'm not afraid of any of them. But conservatives ought to be more concerned with the conservative promoters of this than anything that's coming from the radical crazies on the left. The Madison Coalition is supportive of what the Convention of States Project's doing. I ran into them at a presentation that Mr. Ferris did in Mechanicsville, Virginia back in April. And the head of the Madison Coalition was there. And then at the second round of the Mount Vernon Assembly in Indianapolis on June 12th and 13th of this year, their lead attorney was there coddling state legislators. Yeah, on the surface, just like the Balanced Budget Amendment, this sounds appealing. If you want to put some constraints or checks on this. But they're asking for an enactment of a House and a Senate rule so that if a Balanced Budget Amendment was called, or convention was called, if that's even possible, but for the sake of discussion, Congress calls a convention for the purposes of proposing a Balanced Budget Amendment. And then the convention decided, somebody else that didn't propose an amendment or an application, another state, say Wyoming, decided to, at the convention, propose a term limits amendment or right to life amendment. These guys are trying to encourage leadership in the House and the Senate to prohibit Congress from even considering a measure or a proposed amendment that comes out of the Article 5 Convention that goes beyond the scope of what the Convention called for. These are the same people that tell you that Article 5 was put there to bypass Congress, and now they're asking Congress to pass rules to look at the content of proposed amendments that come out of an Article 5 Convention. Totally ignores the fact that even if you could get them to do this, if it was possible, if it was constitutional, which it's not, but that even if it was, how many times have you heard them suspend the rules? And who makes the rules? This deliberative body makes its own rules the same way the convention does. What I found even more interesting is that this supposedly limits the scope of the convention set by the states who call for the convention. Well, this is also encouraging disenfranchising. It only takes 2/3 of the states to apply, but those 2/3 of the 50 states are no more sovereign than the third that don't apply. At the convention, they're equal as states, as sovereign states. So they're asking to disenfranchise that delegate from Wyoming who wants to propose a term limits amendment at an alleged balanced budget amendment convention, and yet when you look at Article 5, it doesn't require a subject, it doesn't require an amendment up front, it doesn't require anything except for the states to say, hey, Congress, we want a convention for proposing amendments. Call it. And when I was reading this, looking into this from the Madison Coalition, I see this pledge by individual members of Congress to block floor consideration for the same purposes. So that sounds a lot like what Grover Norquist was doing with the Americans for Tax Reform, to get members of Congress to sign a pledge that they wouldn't vote for anything to raise taxes. The Madison Coalition encourages both state legislators, leaders, and members of Congress to work for the eventual adoption of the Madison Amendment to permanently and constitutionally guarantee the right of 34 states, that's the 2/3, who propose an identical amendment to limit the scope of a convention they call to an up or down vote on that specific amendment. That sounds a little convoluted. What they're essentially saying, they want to amend the Constitution, and they're not amending Article 5. They're going to add a third method to propose amendments. What we discussed earlier, Congress can propose amendments, or a convention can propose amendments after Congress calls that convention, after 2/3 of the states apply for a convention. They're proposing that the state legislatures themselves, if they all pass a resolution or an application with the exact same amendment, exact same every period, comma, identical, then a convention would be called, just like Article 5 requires, under the convention method, and all they could do is vote up or down. Ridiculous. Who's been pushing this? Well, it's like the usual suspects. Back in August of 2010, the ALEC International Affairs and Federalism Task Force recommended that ALEC endorse the proposed Madison Amendment to the U.S. Constitution. There's 5 former presidents, and this is in the article promoting it, 5 former presidents of state legislators' organizations are now supporting the Madison Amendment to restore balance of state and federal power. Kim Koppelman, past chairman of the Council of State Governments. I'm not going to write, you can read these names, but you see CSG, ALEC, and CSL, CSG. This is ALEC. This is like saying that Pepsi endorses Pepsi. This is Coke endorsing Coke. Ford and Rockefeller endorsing Ford and Rockefeller. And these are all state legislators who are former leaders in this movement, some of which are still state legislators and are still promoting the Article 5 Convention. Our General Counsel and I attended a National Sovereignty Symposium in Omaha in January of 2010, so 8 months before this, at which ALEC and some of their national leadership of state legislators said they had a plan sitting on the shelf, ready to pull the trigger if the federal government just got too far out of control. Well, they're already out of control. and they pulled the trigger in January of 2010. But the method or the plan, the effort to trigger an Article 5 convention has been underway for well over half a century. I mentioned Grover Norquist and his pledge via Americans for Tax Reform. Well, the National Taxpayers Union also came out a month later in 2010 endorsing the congressional proposed amendment, H.J. Res. 95. Who used to run the National Taxpayers Union that's endorsing the Madison Amendment? Grover Norquist, CFR, Council of Foreign Relations, globalist. What I found interesting about this resolution on the Madison Amendment, and this isn't the actual verbiage of the amendment, but to give you a sense of what Congress thinks about this, it's proposed that this is a summary from H.J. Res. 95 from the 111th Congress, which is just a few years back, proposing an amendment to the Constitution of the United States allowing the states to call a limited convention. If you need a constitutional amendment to allow a limited convention, what does that tell you about a limited convention now without this amendment? If you need a constitutional amendment to call a limited convention, then there's nothing in the Constitution now authorizing a limited convention. And there's not. So who's looking at this from the left? Well, this is just one faction, Move to Amend, which is end corporate rule, legalized democracy. When they talk about retaking or restoring our democracy, we don't live in a democracy. We live in a constitutional republic. The Constitution guarantees us not a democratic form of government, but a republican form of government. Thomas Jefferson said, democracy is nothing more than mob rule, where 51% of the people can vote away the rights of the other 49%. This progressive effort, at last count, there were over 417 progressive socialist organizations also pushing for an Article 5 convention. Some of them you might be familiar with, such as Code Pink, the Sierra Club, Occupy, Social Justice Committee. Social justice is one of those tenets of sustainable development. Environmental justice, economic justice, social justice. The Progressive Democrats of America. The Green Party, Communists. Occupy from coast to coast. Move On. There's Mr. Soros's groups. There's several move-ons and variations of moveon.org. There are I've got nine, I think there's like 9 slides just of the progressive groups that are affiliated with this particular Move to Amend. I believe it's movetoamend.org. Look at the MTA partners, and you'll find all these. And it goes on. Remember Acorn? Had 1,000 tentacles of different organizations, small and large. To say that for the conservatives, to say that progressives and socialists and the people on the left aren't even interested in an Article 5 convention is 20 Pinocchios. And that's it. This was as of May 10th. I looked at these numbers again about a month ago, and it was over 417 at that point. It's probably even more now. Major deceptions of the Article 5 movement of the promoters, that an Article 5 convention is a convention of states. That's a lie. An Article 5 convention can be limited to a single issue. Well, limit means reduce, according to them. Limit does not mean reduce. Limit just means you're putting boundaries on. You can expand government with new limits. Robert Kelly, their staff counsel, admitted at the debate in Yorktown that limit doesn't necessarily mean reduce, and that their application that they were calling limited was broad. In the video we did with Dr. Vieira, he acknowledged this as well. If you look in Black's Law Dictionary, limit does not mean reduce. This means puts limits on. And that's one of the deceptions. These are major deceptions and myths put out by the promoters. That Article 5 Convention is controlled by the states. No, it's not. It's controlled by the Constitution. If people don't like that, then they do need to amend it. But to suggest that it is a lie, because an Article 5 Convention is a federal convention. It's a federal process. Both the courts and Congress have recognized Article 5 Convention as a federal process. It's called the Federal Function Doctrine. Excuse me. These state, local, or state legislators, when they are performing their duties under Article 5, they are acting as federal officers. And they are federal officers because of that oath they took under Article 6, Clause 3, in the fulfillment of upholding the supreme law, which is Article 6, Clause 2. It's not controlled by the states. It's not controlled by our Congress. They say that Article 1, Section 10 is an alternative method to Article 5. The Goldwater Institute put out a document in which they said, and they're trying to do by fiat what the Madison Amendment, the Madison Coalition is attempting to do with an actual amendment to the Constitution. They are trying to get states to enter into a compact to put in their applications the exact language of an amendment for a balanced budget, for example. They've actually got, I think, 18 amendments that they're wanting to hold essentially one day per amendment. Article 5 conventions or amendment conventions where people from the 50 states fly in, vote, fly out. To suggest that an Article 5 convention will be one state, one vote, well, it probably will be. Initially, it will be. But once the convention is called and convened, the gavel bangs, they're going to elect officers, and they're going to adopt the rules of the convention. They can adopt the rules that Congress proposed. They can adopt rules that the state proposed. They could throw them both out and write their own rules. And there's nothing that the states or Congress could do about it, no more than the state government could, if they didn't like the rules that Congress has, that the Senate and the House have, there's nothing that the state legislature or state government can do about Congress, how it conducts its business, no more so than Congress can with the state governments. An Article 5 convention is a federal deliberative body, just like Congress writes its own rules, acknowledged by both Congress and the courts. But the promoters don't want to talk about that. They want to say, well, Congress doesn't control. Well, neither do the states. Don't fall for the carrotocracy. Those promoting an Article 5 convention will dangle every carrot they think you'll jump at in order to trigger an Article 5 convention. You get the facts below. And this is our Article 5 resource sheet, and it's actually got links to more pro-Article 5 convention organizations than those against, because we're not afraid of the facts. We need to have an honest, open discussion about this whole dog and pony show that's an Article 5 convention, and who's behind it? And is it even the real solution? Will it even solve the problems that they suggest that we need to have this convention for? No. Let alone the real problem, which is in the mirror. It's us. So we're changing the Constitution, make public servants follow the Constitution. So we need to ask the right questions. We need to address the root problem. This is the Kansas director for the Convention of States Project, Mr. David Snyder, who had debated our general counsel, Mr. Fry, about a week or so earlier, or actually just a few days earlier, speaking to a group in Kansas, and a gentleman got up and asked him about the president. You know, if we go down this path of triggering an Article 5 convention, what's going to make the president follow those new amendments? And Mr. Snyder admits, well, it won't. You know, we're going to have to deal with that whether we go down this path or not. Well, why don't we try to uphold the Constitution as written before we go tinkering on it? I say an Article 5 convention is Russian roulette with the protections of our God-given rights. But instead of one bullet chambered, there's only one chambered empty, because we, the people, are not going to be the delegates at this convention. I would trust delegates that were picked from throwing darts at a phone book more than I trust these puppets of these NGOs and billionaire boys club groups. The funders of most major political candidates and campaigns is not Joe and Jane Citizen. It's corporate America and individual billionaires. Ask the right questions, address the root problem. The root problem with the Republic is that we, the people, are not holding our public servants, general or state, accountable. Until we hold them accountable, no change to the Constitution will matter. Once we hold them accountable, no change to the Constitution will be necessary. So what are the solutions to the Republic's problem? Well, we need to educate citizens on the Constitution and the fundamental principles of federalism so they can hold politicians accountable. We need to take back the states so they can uphold their duty to rein in the central government. 3, but to take back the states, we need state constitutional amendments in most states, because some have the ability to recall, some don't, to give the citizens the power to recall every state officer from the dog catcher to the governor. We need ballot initiatives to pass laws that the state government won't pass, and referendums to repeal laws that the state government won't repeal. So what if the people will not learn the Constitution and become active in holding our politicians accountable? Well, as our general counsel said, this is a Jesus on the cross moment. It's where we are. Luke 23, verses 33, and then again at 39 through 43. It's the conversation that the two criminals that were on either side of Jesus on the cross, one of them mocked him, and the other one asked for his forgiveness. That's where we are as Americans. That's the crossroads America's at. Can we trust these people to solve a problem when they refuse to even admit the real problem? No, we can't. We have to address the root problem. To get the control of the federal government, we must get control of the states. To get control of the states, we need recall, initiative, and referendums. That ability. We need to be ever vigilant in defending our God-given and inalienable rights. We need to restore constitutional governance. Our motto at Patriot Coalition is that defending life and liberty is the pursuit of happiness. It starts with us. We have to vet candidates. If we don't know what our rights are, we're not going to know when people are walking all over them. If we don't know what protections we have of our rights in the Constitution, whether it's the federal Constitution or the state Constitution, how are you going to know what questions to ask the candidates that are running for office? And how are you going to know what answer to expect back from them? As politicians, they're going to tell you whatever they think you need to hear to get your vote. Well, how's that been working out for us? Not very well. But common sense questions. We approached these at the front. Would you suggest amending the Ten Commandments because people break them? Of course not. It's absurd. If your spouse was cheating on you, would you say, you know what? I have a V8 moment. I guess I'm going to amend my marriage vows because my spouse is cheating on me. Would you consider that? If public servants, your governor, president, your congressman, your mayor, your dog catcher, if they're not keeping their oath to uphold the Constitution, which is to protect your rights, your freedoms, your liberties, why is changing the Constitution the solution? It's not. If you want to learn more about the Article 5 amendment process, if you want to arrange for a presentation in person by either myself or our General Counsel, Mr. Fry, you can contact our Deputy Director, Ms. Dee Sadler, at this address, d@patriotcoalition.com. You can get our Article 5 resource document. You can get the main version of this PowerPoint, so I've got a few extra things in this, the PDF of it at this address. You can also, before I get to all these questions, and I'm going to end the recording here in a second, you can also please go to rejoinorDie.com. That's our Article 5 site. You can visit us on Facebook at Patriot Coalition, also Fire Coalition and America's 11th Hour. We do radio shows on BlogtalkRadio at blogtalkradio.com/Patriot Watchdog. And the published version of this, when I publish this video, I'll include all those links. But I'm going to stop the recording of this now. I think that's the last slide.